Undimu, together with my colleague Ms. Maika, Ms. Kerubo, Mr. Kirago, and Mr. Jorogi.
Perhaps before we read the plea, I'm going to ask all of you to just step aside. Leaving that gentleman. Please just step back so that you give him his space.
Your Honor, if you may.
Yes,
when we were waiting for Mr. Morara to introduce before you, I indicated to the court that we have another person so within the precincts of the court, Honorable Finnegan Waitito. I am afraid that he has not been brought before you, yet it's within the precincts.
Your Honor, there are two different files. Once we are done with this, definitely we will produce. I don't know why you think they are on the same file. I indicated to him there are two different files.
David Morara, alias Morara KEBASO, Senior. These are your charges. You're charged with cyber harassment, contrary to Section 27 of Computer Misuse and Cyber Crimes, Act Number 5 of 2018. David, on the 28th day of September 2024, at a known place within the Republic of Kenya, doing so with others not before court, while using X account dumped at Morara KEBASO Senior, you knowingly, without lawful excuse, posted false information to which, I quote, William Ruto approached DL Langat and told him he desperately needs more money for campaign. DL Langat used his property as security and took big loans to help his friend. Right now, DL Langat is being auctioned by banks, and the person who is buying the property is William Ruto. To make it worse, William Ruto has used his powers to undervalue the property to buy them at a cheaper price. That is the type of a person we are dealing with. He has no friend. Contact whose information you knew to be false and calculated to tarnish and discredit the reputation of one David Langat. Is it true or not true?
Before he pleads, Your Honor, it looks like there is a mismatch in the charge sheet, and that it may not be worthy of pleading to. So we'll be asking you to reject it under 89. If you look at the charge sheet and the particulars, if at all any name was to be tarnished, probably it would be that of William Ruto. If the particulars were not true, it would not be the name of David Langat. So what is the fear of putting the name of William Ruto as the complainant? This is a very, and you can see, I don't know how it has been drafted, but if there was a name to be tarnished here, the person who is looking like ungrateful and not quite a friend would be William Ruto. So I'm urging the court to read the charge carefully and reject it, because it doesn't make sense. Something is not adding up.
Stupid.
Even if we go to trial on this, and even if David Langat comes, it will not be sufficient without William Ruto as the complainant.
Yes, Your Honor. Just to be traced on what senior counsel. just to be traced on what the senior counsel submitted on, there is no doubt that the particulars of a charge sheet must be able to inform the accused person what he or she is pleading to. And that the particulars of an offense as drafted. And that the particulars must speak to the alleged offense. They must clearly square out the subject of the complaint to which our client has been brought to you to lead to is one Mr. William Ruto. And therefore, if the offense as drafted was to have any meaning in law, to the extent that our client is able to respond either positively or negatively, the particulars must relate to the subject. To that extent, Your Honor, this charge sheet is defective. It is not worth the paper it's written on. And our client is not able to plead it, as the particulars do not inform on how he should plead. It does not disclose who is the complainant. Is the complainant Mr. William Ruto, or is it B.L. Langat? And this is so important, Your Honor, and fundamentally important under Article 50, in the sense that we shall be requiring the statements of the complainant at the trial or at the fullness of time. So if a charge sheet is jumbled up as it is, Your Honor, it's only causing embarrassment to our client and to this court. That's all, Your Honor.
Your Honor, if I may,
Just a moment. Yes, ma'am.
Your Honor, if I may, the charge sheet brought before you this afternoon, Asha Rashid.
And I saw that you don't take a lot of time on
Yes, I'm only raising one
just a
issue.
request that you also put what we are
Yes,
asking.
yes. I'm only raising one issue, that the alleged complainant here is also not a witness. I'm wondering how the two police officers will be the witnesses in this matter, yet the complainant is not. So I humbly submit, like my seniors before me, that this is a faulty charge sheet and should not see the light of the day. Thank you.
Your Honor,
Your Honor, I'll make a very short statement.
Just a moment.
I'm Willis OTIENO. An accused person
Just a moment.
an accused person under Article 50 under Article 50 of the Constitution, an accused person has a right to be informed in sufficient detail of the charges proposed against him. Sufficient detail. What is presented as a charge sheet, if you look at the count 1, it talks of cyber harassment. But look at the particulars. That is where the devil lies. And where the devil lies, it sets out a purported ex post, but proceed to show you where he's sleeping. Content whose information you knew to be false and calculated to tarnish and discredit the reputation of one David Langat. This speaks, Your Honor, to a question of reputation, not harassment. And if it is reputation, it's defamation. If David Langat or William Ruto thinks that this post has injured their reputation in the eyes of right-thinking members of the society, their recourse is in the civil courts. They sue for defamation. And criminal defamation is no longer applicable in our legal system. So that if the particulars presented before you all yes.
Given that they are going to engage with blood pressure, we just check on the words so that
And it's something like I know sometimes I sting like a bee. Let me try to be the butterfly on the arm. I not inject. So, Your Honor, the particulars disclosed in the charge sheet speak to defamation, which is a civil wrong. The count in the charge sheet speaks to cyber harassment. There's disconnance in the two. So will Mr. Morara be required to respond to the count of cyber harassment or the particulars of defamation? That charge sheet, Your Honor, should not be registered at this particular point. And the state can advise the complainant that in relation to reputation, the Chief Magistrate's Court Milimani exists, Civil Division. You can go there. In relation to cyber harassment, the complainant should come with better particulars, not these ones. So having dissected those two, the particulars of the charge and the count on the charge sheet, Your Honor should exercise your discretion and refuse to register this charge as presented before you, and direct that Mr. Morara to be set free forthwith, unless otherwise lawfully detained. Because this is prejudicial at the outset. That's all.
You know, with very, very kind permission. Your Honor, this is
That's what justice deserves. That's what
it's
it is.
extremely important.
Challenge with us lawyers. We report to what we don't know. We don't know what we're going to say. So I've been working manually because we had not set up the gadgets. We didn't know this case of this nature was coming. So now just for your information, because now the gadgets have been set up, I will now not be writing. But please, when you speak, say your name at the beginning and use the microphone. So we have the transcription.
Your Honor, with the very kind permission, the matter is from Morara, and I wish to address the court as follows. Your Honor, I'll pick it up from where my learned senior Mr. OTIENO left it, and urges to go straight to Article 25 of the Constitution on rights that cannot be limited, Your Honor. One of the rights that cannot be limited, and while all other rights can be limited, is the right to fair trial. You know, that is under Article 25C of the Constitution. Very quickly, Your Honor, I'll, with humility, invite the court to read that together with the provisions of Article 52B, which my learned senior, where my learned senior left. 52B, Your Honor, is about the right of the accused person to be informed of the charge with sufficient detail to answer it. Your Honor, what has come out in the few minutes before, Your Honor, 50 sub-article 2B. If I'm not wrong, Your Honor, it talks about what fair trial, all that is under Article 52, from 2A all through to 2, I believe, J. 52A all through to 50Q, Your Honor, is what constitutes fair trial. Such that, Your Honor, as we stand before you this morning or afternoon, the accused person is clearly not able to understand, Your Honor, what he's responding to. And these are provision, Your Honor, or these are right, Your Honor, which cannot be limited. I invite court to find basis on those two articles, Your Honor, to reject the charge sheet that has been read out. That's all from me, Your Honor.
If it pleases Your Honor, I'll leave the floor to my learned senior.
Yes, Your Honor, I just wanted to say one or two things.
It's being transcribed, so you can start by saying your name.
Yes, Your Honor, my name is Eric Theuri. Your Honor, you've been referred to articles of the Constitution. I will not seek to rephrase what has been stated before you, although I agree entirely with your submission. But Your Honor, so that you are not told that this court cannot deal with questions of constitutional interpretation, Your Honor, I also wish to refer this court to the Criminal Procedure Code, and I would want to make reference to sections 135 with regard to the framing of charges.
Section
135 with regards to the framing of charges. And Your Honor, it underpins the constitutional requirements that an accused person is entitled to sufficient information be in a position to respond to the charges that have been made against that person. Your Honor, secondly, you have the jurisdiction and the discretion under Section 89 of the CPC to decline these charges if you are of the opinion, and Your Honor, we persuade you to be of this opinion, that the charge sheet before you does not, in sufficient material, disclose a case to enable the accused person take a plea. Your Honor, I'll finally say this, and I think I have said this before. If we continue at this rate, we will have to seriously expand this course. Because, Your Honor, what it would mean is that any statement that a person can make under the free speech that is guaranteed in this country. Sometimes, yes, I can say something that can be offensive. But does that constitute a crime? It's the danger that we face with this kind of language. And Your Honor, for those reasons, and being that these courts are temples of justice, there are games that can be played out there. And Your Honor, I think it is also important for me to say that this court has recognized, and the High Court, I think, has recognized the manner in which of late police have been conducting their arrest by way of abduction of those people they consider to be suspect. There is actually an order of the High Court that has directed that the police must comply with the law when it comes to effecting arrest. So when someone is abducted, like the accused was abducted, in clear contravention of a court order, and then he is brought here for the court to sanctify the actions, the illegal actions that have been undertaken. And the attempt to sanctify, Your Honor, those actions does not meet what is contained in our laws in terms of the kind of charges that should be presented and accepted before the court. Your Honor, this court must remain what it is supposed to be, a court of law. We may not be able to stop the police in the manner in which they are behaving. But there must be a place where they know so that they can play their little games outside there with the lives of each and every one of us, because it basically means that no one is safe. I can make a statement that it is deemed criminal. Let them know that those games will not be entertained within the... And so, Your Honor, I plead with this court that we must take all the circumstances of this case, and the circumstances of this case then explain the paucity in the charge sheet as has been presented before you.
Your Honor, if you have an emergency of budget, and it's important and court, and the record of this
Any medic? Don't administer first amount.
On the side. Thank you, Your Honor. It is the last time we appeared in court over this matter. The court had to buy me. I was avoiding that because I don't want it to go on record. But it looks like, I mean, as a certain need to think about first aid and whatever, if we proceed in the manner that we are proceeding. But Your Honor, what I was saying is that the circumstances of the arrest then demonstrate why.
Can I interrupt?
Yes, Your Honor. Yes, Your Honor. So my final point was that even though it might appear to be an overreach, but this court must look at the circumstances of the arrest, and it will be able to understand that the intention here is for this court to be a conveyor. We abducted him, we were unable to. So, Your Honor, what I was saying is that this court is then intended to be a conveyor.